Hello, welcome back. I'm Roger Royce. I'm a partner with Haynes Boone. I do emerging growth and venture capital for mostly tech companies in Silicon Valley out of our Palo Alto office. And today we're going to talk about the influencer economy. So, just as of this date, late September, just last week, were the American Bar Association Business Law Section meetings, and I had the opportunity to sit in on a session moderated by Professor John Garon on influencer economy and the law around that. And I was really blown away, to tell you the truth, as to all the legal issues that come up. And well, number one, the legal issues. And then secondly, just how big an industry this is. So Professor Garon is a professor of law and director of the Goodwin Program for Society, Technology, and Law at NSU Shepherd Broad College of Law, where he was dean from 2014 to 2020. He focuses on privacy, free speech, and technology law. He's published over 70 books, book chapters, and articles, and has presented at over more than 300 programs. So very prolific. And some of his books, by the way, include how AI, metaverse, crypto, and cyber will upend the 21st century, parenting for the digital generation, and a short and happy guide to privacy and cybersecurity law. So there's a very broad range, but we're going to focus on influencer economy here today. So thank you for being here today, Professor Garon.
Oh, I'm delighted to be here. Thank you so much for having me.
Yeah. So let's kind of jump right into it. And because I needed a little bit of explanation myself, so maybe some of my listeners do. What exactly is this influencer economy and why is it so important?
So the term influencer economy tries to capture the idea that as we've moved from mass media to social media, most of the advertising decisions today are being pushed to us through algorithms based on our personal interests. And a lot of that is generated through the individuals that we follow online. So an influencer is anyone who is interested in promoting a product or service for compensation of any kind. We can talk about what kind of compensation that is. And this is becoming increasingly the primary way that advertising and marketing takes place on the internet.
Okay. All right. Got it. So, and we've all seen influencers, right? You can't avoid them. Uh, in fact, if you spend any time at all on social media, it's interesting what you said. It's the primary way now that advertisers are getting to their customers. So, of course, I got to believe that there's potential for abuse and there's got to be rules and regulations around this. So, who primarily regulates this and what's generally required?
So as we moved from mass media to social media, we moved out of the control of the Federal Communications Commission. The FCC regulates advertising on television and radio, and instead we've moved into the Federal Trade Commission's control over unfair and deceptive trade practices. The FTC Act itself goes back to the beginning of the 20th century, I think 1910, but it continues to be a very flexible doctrine that looks at anything that is deceptive to the public or that is deemed to be unfair to the public in the way that it's structured.
Yeah, and deceptive and unfair seems to be an evolving concept, doesn't it? I mean, we've all read in the papers about athletes and famous actors and people getting in trouble for endorsing things. What can give me an example if someone's going to give an endorsement, what do they have to use the product? I mean, how do those rules work?
So again, the FTC Act itself has this very broad category of language, unfair, deceptive trade practices. But what that means under the guidance is that whenever somebody is speaking on behalf of a company, they can only say those things that the company itself could say. So if it's a weight loss product and there's limits on what the company can say about the effectiveness of that weight loss product, then the individual can't go out and espouse a different experience. even if that experience is true, there may be guidelines on what can be said about the product. And of course, if that information is not true, then it absolutely would violate the deceptive trade practices to talk about a product that works. In the crypto space, we saw a number of athletes and celebrities endorsing various crypto products. In many of those cases, the FTC brought actions because the individuals did not, in fact, invest and retain those assets that they talked about. And so the way that they were talked about on social media, and in some cases in television advertising, was not the same as what the endorsers were actually doing. But it's not just the major celebrities. This is true of micro celebrities, micro bloggers. You can be someone with 10,000 followers or smaller and still have endorsements, still get products in kind in exchange for promoting them online. And so the policies apply even at that level.
Yeah, and I gotta believe that they apply pretty broadly, but you tell me. For example, I represent a lot of companies that have products, and I've actually had this happen. And they come to me and say, "Hey, could you do an endorsement for me?" I'm not famous, I'm not a celebrity, um, but I have to sit and wonder. Well, I don't know. I guess I probably have to disclose to the world that I'm your lawyer if I do that. Uh, and I certainly have to use the product, right? And not just one time. And whatever experience, I think what I'm hearing from you, whatever experience I talk about can't be just one of those rare one-off kinds of things, right?
Right. So there's two different things there. Number one, the relationship between you and the company must be disclosed. So if you're their attorney, you need to make sure that that's now public. That adds a whole additional layer, of course, because that's also an attorney-client disclosure in addition to an endorsement disclosure. So you have to deal with that side of it. Secondly, it has to be accurate. So you need to be describing it in a way that actually reflects your own experience. And then in that accuracy, it also can't violate any limitations that other regulations have on the company to not say things that the company is not permitted to say. And in some fields, there are statements that what the company itself is barred from making claims, particularly pharmaceutical claims. And
Yeah,
so those limitations apply to their spokespeople as well.
gotcha. So let's suppose that it sounds like these rules are evolving and changing, and not everyone knows about them, and people are going to make mistakes. Like even as you're talking, I can think of cases where I've seen online where I kind of wonder, what's the downside? What's the penalty for this, and who's going to get you? Is it the FTC?
So the FTC is the primary federal enforcer. But of course, every state has its own mini FTC act. And so if you are active in a particular state as a company, but not necessarily nationally, you could run afoul of the Attorney General. Generally speaking, there are not private causes of action in this space, but of course, common law fraud, if you're saying something that actually is manipulative to a consumer, then common law fraud, breach of contract issues, and the like can come up, and those could lead to direct liability as well.
Yeah, that was going to be my next question because we all saw a bunch of lawsuits against influencers around FTX and other companies as well. And so what you're saying is that didn't derive from the FTC rules. That derives just from the state common law fraud rules. Is that right?
That's correct. I mean, obviously both are in play, but when you have massive fraud like that, misrepresentation, the people who are participating in it, who have knowledge of that activity as they promote those activities, that's federal and state, both criminal and civil liability for that. But if you're just an endorser and you get a product in the mail and say, try it out, tell us what you think, that is going to generally not trigger the kind of scrutiny that we're talking about. The FTC has tried to really push guidance and to encourage companies to do the right thing through action letters rather than to bring people into an actual regulatory proceeding.
Yeah. And I guess taking a little bit of a step back, I keep talking about social media, but it's a little broader than that, isn't it? I mean, it could be websites, it could be other sort of public, I guess, publications. Is that right?
Well, certainly. Again, influencers will range, right? So you have various memes that will suddenly appear, even showing up on television or radio shows. So there's no limitation. Just because the FCC has regulation over broadcasting doesn't stop the FTC from being involved in unfair and deceptive practices. So they have plenary jurisdiction over all these activities. And in addition, if it turns out that the statements were inaccurate and resulted in promises that were made contractually that were false, those contract claims, again, it doesn't matter which format it is. So whether it is a social media platform like X or Meta, or if you're talking about websites where companies are posting or putting on clips, all of those things are going to be included, but all the way up to commercial broadcast.
Okay, gotcha. Now, one of the things I learned down in San Diego at the ABA meetings is that there were some 2023 updates to these guidelines. So for people who might follow this area, is there anything new and different that they should be aware of?
The real focus of the most recent guidance is to really emphasize the obligations of disclosure. It is difficult if you are an influencer to on TikTok or on X with very small windows to describe the fact that you're in a relationship with that company. The FTC reiterated in the new guidance that it is a requirement, and just because it's small, using a hashtag sponsored or some other technique to make sure that it is clear that there is a relationship is really the cornerstone of the disclosure requirements.
Now that's interesting. Hashtag sponsored. That would be something that would be advisable in these cases, it sounds like, or something like that.
Yeah, that's really the floor. Everyone who is receiving any kind of and financial or other kind of compensation. And that's something else that the FTC was really focused on. If you're getting free tickets to a show, if you're getting comped hotel rooms, if you're getting products that you get to keep after you've reviewed them, all of those kind of relationships must be disclosed as part of the process.
Gotcha. Okay, let's turn now to, something that I think is really interesting here, and that's the use of AI and avatars and how these rules might apply now to the fact. Well, first of all, maybe you could tell us a little bit about how avatars are being used in this space, because this was a surprise to me, even.
Yeah, I find this to be just a fascinating part of what's going on in practice, and obviously it has legal implications as well. So, as AI has become better and better at developing photorealistic imagery, increasingly we're seeing the use of AI generated personas to serve as influencers. Some of the top AI generated personas have millions of followers. They're active on social media platforms like X, like TikTok, and the like. Their personal life, their home life, is documented on these sites. So you see, actually, in the photographs, it's really amazing how well these are done. Um, one of the models, they tend predominantly to be female models. One of the models is rather striking when you see her in her commercial setting, but then her homepage also has pictures of her in her bedroom hanging out with friends. You see her freckles more prominently. You see what she looks like when she's theoretically not airbrushed versus when she's on camera for a photo shoot. But of course, all of these are digitally generated AI imagery. There's no human being behind it. Um, the persona is entirely owned by a marketing firm. The marketing firm therefore controls all the messaging, controls the brands, is able to create this space. And the data suggests that 10% or more of the public is not even aware that the person they're following is synthetic.
That's amazing, isn't that something? Of course, well, let me just ask, I guess there's no obligation to tell them that, right, under the FTC rules.
So the obligation is to show that there's a relationship between the product and the spokesperson. But so long as that's disclosed that this is a sponsored advertisement, the FTC has not taken that extra step and suggested that the lack of human as the persona is a required disclosure. Now, interestingly, there are some emerging state laws that require that when you're speaking to an online avatar, that the fact that it is a bot rather than a human being, that must be disclosed under, I think Washington has that law now, Colorado has developed that law, and a few other states to try and protect consumer fraud on that side. Potentially, those state laws could eventually be applied to the digital influencer as well.
Yeah, and California currently, I understand, has 38 bills waiting for the governor to sign. He signed some of them relating to AI, and a lot of them relate to disclosures online. But how about that? Are the states getting pretty active in this, or is this mostly federal?
Federal law has really not kept up. And so you have just a tremendous number of new state laws. I mentioned Colorado has a new law that focuses on certain kinds of privacy and use of AI for certain kinds of activities. And in it, it includes the chatbot. It's primarily focused on deceptive AI in housing and employment relationships, algorithmic bias, and things like that. But it is broad enough to include these. Washington State has a law that's primarily focused on healthcare access and protection of healthcare data. But again, it's written in a very broad manner and may cover things that weren't originally intended under that law. California has been the leader in this area. But as you say, with, I believe, at least 6 laws were enacted, were signed into law last week, and many more on the governor's desk. It remains to be seen what the package will actually look like, beginning next month when we know what's signed and what's been vetoed.
Yeah, it reminds me a little bit of, data laws back when, and where you got all different states coming up with their own rules, and California was right out there in front. And, there might be a time when we need some sort of federal preemption. Hey, let me change gears again. Here's another term that I'm embarrassed to say I didn't know. I had not heard this term until I read it in your materials: digital redlining. And well, maybe I should. Can you tell us what that is and how it's being used now?
Sure. So there are a number of issues in the online space that go to issues of bias and access. So the digital divide people are very familiar with. Simply the cost of having technology makes these uses available to some companies, but not other companies, right? Access to some individuals, but not others. And the cost of entrance, the communities that are underserved tend to correlate very highly with race. And so we see that broadband is not nearly as prevalent in inner city communities as it is in suburban communities, although that's also an issue in rural communities as well. Digital redlining is kind of the next phase of understanding what's going on in the bias of technology. The use of algorithms to use behavioral or psychographic targeting allow advertisers to really hone in on exactly who they want their customer to be, who's receiving their information, and who's not receiving that information. And again, from an advertiser standpoint, you want those individuals who are the most affluent, who are the most likely to subscribe to your product, likely is the person that you want the most. Of course, there are also more predatory businesses that focus on people of limited means and limited information and provide products to them. Digital redlining simply reflects the fact that companies can use these psychographic, behavioral, and demographic tools together to paint a very accurate picture of everyone that they're targeting for advertisement and use these lines, uh, often lines that correlate very highly with race, national origin, to provide or not provide advertisements and services. If we think about just advertising, that seems relatively neutral, who gets an ad or who doesn't. But if the advertisement is for housing, if the advertisement is for employment opportunities, the advertisements related to healthcare information, suddenly those are protected areas under federal law. And so there's a real concern that companies may not, in fact, even realize that they're violating federal protections of to protect classes for suspect situations. And so it's really important that as advising companies, we're asking those questions about how are they differentiating their audiences and making sure they're not using surrogates for race, gender, ethnicity, and other protected classes.
Okay. A couple concepts I want to make sure we talk about in the time we have. We talked quite a bit last week about the right of attribution and how U.S. law varies from the laws of other jurisdictions. Can you tell us a little bit about what that is?
Yeah, so the right of attribution stems from a copyright concept. In the rest of the world, independent of the right to reproduce a work or distribute a copyright protected work, there is a right of the author of the work or the creator of the work to have that person's name associated with the work. The United States did not adopt that rule when it adopted the Berne Convention back in the 1980s, explaining that our trademark law provided a similar and therefore sufficient level of protection. The Supreme Court's interpretation of the trademark law has, in fact, eroded that argument. Copyright preempts trademark law when they clash. And so there is no right to attribution in the United States unless one has been negotiated by contract. And as a result of that, information, content can be used with, right, even under fair use, it can be used without having the human dignity to protect the individual. That lack of attribution is one of the missing safeguards to protect from false endorsement claims, right? So if a digital persona, someone is duplicated without their permission online, most states and the federal law do not have clear statutory protections to stop an advertiser from using a person's identity without permission. The Lanham Act does have an unfair competition provision, but it's awkward and it's inconsistent. And so in Tennessee, we now have the Elvis Act that particularly give this right. One of the bills, actually more than one of the bills that was just enacted in California, extends this right, but it's really a patchwork. And so one of the things that the Copyright Office and many of us in the field have been advocating is that we go back and restore or create an attribution right under U.S. copyright law to help solve some of this gap.
Let's talk a little bit more about that. So when you say a right of attribution, so this is something that goes beyond kind of the current, we're not just exactly copying something. It's like you talked about the Elvis Act. I tell me if I'm right. I assume what you mean is that if somebody, because the example we gave last week is that there are dancers on TikTok who got their dances from people who are not on TikTok and don't get any credit for having invented the dance. So that's pretty much the classical case. Am I right?
Yeah, so that's an example where a dance is a choreographic work. It's protectable by copyright. The dance is probably on TikTok maybe too short to protect by copyright. But the dancers who are well known, who've created these signature moves, are not being credited at all, certainly not being compensated. And if we had a right of attribution, it would go a long way for those individuals to get the recognition that they deserve for those rights. And again, as we see in most of these areas, It tends to be the minority creators who are left out of the economic opportunity. So in the case of the TikTok dancers, it's almost exclusively African American artists who aren't being credited and aren't being compensated for their work.
And that's the next part, because as a lawyer, the way I think about it, well, if there's a right, I mean, the right means you can stop somebody. They have to get your permission. So they would enter into a license or something like that, like we normally do. Let's take that one step further. So, like the Elvis Act, so if somebody imitates Elvis, I'm gathering the Elvis estate should be able to consent to that or license that. And in my mind, I'm kind of going, the next step, well, who did Elvis imitate? And who did he borrow from? And the more I think about it, even Hank Williams, kind of the country singer, that we all know, in his youth, he listened to African American blues singers, and it heavily influenced his music. So I'm kind of wondering where you draw that line, and maybe that's what the courts and the law have to do.
So understand that the statutory protections under the Elvis Act draw a very narrow line. So this is focused almost exclusively on audio sampling, where an actual digital fingerprint is taken of the performer's voice and trained an AI model to exactly replicate it. Right? There are a lot of Elvis impersonators, and the law doesn't go to a different performer impersonating that individual. So long, again, two separate ideas. So long as there's no idea that Elvis or the Elvis estate is endorsing a particular product, the law does not go to shut down the Elvis impersonators of the world. But if you are taking a voice and digitally recreating that voice, so now you have a perfect reproduction in perpetuity, the law does protect from that misuse.
Okay, got you. All right, so the law has not quite gone there where I was talking about yet. Kind of the last legal issue is we hear a lot about a right of publicity. Can you tell us a little bit about what that is, and does it exist? Is it a federal law, a state law, something we can protect?
Yeah, so the right of publicity is closely tied to this right of attribution, right? It's the use of one's name, likeness, identity, or persona to protect an individual from having that identity right used for the commercial endorsement of a product. And so in many ways, that's really where all of these endorsement guidelines start. It is not legal for a company to take a person's identity and put their picture on their product. And this goes back to the early 20th century. In 1890, Warren and Brandeis were describing companies who were simply, finding girls that they found pretty and putting them on products. And courts beginning in Georgia in 1905 said, no, if you're going to use somebody's name on a product, their picture on a product, you need to get a commercial license from them. You need to have their permission. So the law of publicity rights has always been a state-based law. The majority of states have it by either statute, common law, or both. Importantly, no state has ever said it doesn't have it. It hasn't been litigated in a number of jurisdictions, despite the fact that it's 125 years old. It just hasn't come up because most companies, again, look to the law of California or New York, both of which have very robust and rigorous enforcements of right of publicity. And so if you meet the obligations under your New York or California law, you're going to be fine across the country. And so that's the core right. And then so that now we have the question of, okay, what about a digital reproduction of your voice? Does that fall into the right of the publicity? What about a caricature of you? What about you being turned into an avatar in a video game? And so there's a lot of interesting legal questions as we move away from a direct commercial endorsement to the use of one's avatar or digital persona in online content.
Okay, gotcha. All right, well, we're kind of at the end of our time. I just want to mention that in your materials, which I believe are available through the ABA Business Law section, you have quite a bit of let's almost like a checklist of things to go into agreements with influencers to make sure we're covering all these points, which thank you for that. I'm going to find that extremely useful. And also, Professor Garon, I just want to thank you for being here today. That's a lot of information in a small amount of time. There's a lot more to this area of law than I think a lot of people might have expected, and I appreciate you sharing your knowledge with us. This is Roger Royce. This has been the 10,000 Startups Podcast. And I want to thank you all for listening, and we'll see you next week.